So through this network, we aim to provide space for information sharing and practice development that focuses on embedding human rights in the work we do. So we've got some fantastic speakers here joining us today. So each speaker is an expert in their respective field and they're champions of human rights, and we'll be sharing their expertise and some of the most important human rights milestones, successes and opportunities that have occurred for the community sector this year. So the presentations will also give us some insight into how we can keep driving progress in 2025. So firstly, I'd like to introduce Commissioner Scott McDougall, who's the Queensland Human Rights Commissioner. Next, I have the pleasure of welcoming Professor Elena Marchetti from Griffith Law School, and also Janet Ransley, who's from the School of Criminology and Criminal Justice. Last but certainly not least, we have Daney Faddoul, who's the campaign manager for the Federal Human Rights Act from the Human Rights Law Centre. So hi everyone, so welcome. With each such an esteemed panel, we are set for a session filled with compelling discourse and thought-provoking ideas today. So our first speaker today will provide an overview of some of the key human rights milestones that have occurred in Queensland this year, including the new anti-discrimination legislation. I'd really like to introduce Commissioner Scott McDougall. Welcome.
Thanks very much, Samantha, and good morning, everyone. So I have a set of slides and I don't have control of them, so I'm just going to ask someone just to move through them, starting with the acknowledgement page. So I would like to acknowledge the Turrbal people whose country I'm coming to you from today, and the Yuggera people across the river. I think as I do acknowledgements of country, it's almost impossible not to ignore, the reality of what's going on for Aboriginal and and Torres Strait Islander people and other First Nations people around Australia, and particularly with the news of the termination of the truth-telling inquiry in Queensland. I think, in terms of my slides, I haven't featured that in the milestones that I'll take you through in a moment. But to me, that is a massive milestone and a regrettable one that is taking us well back. And I just would say that in my engagement with the incoming government, I'm stressing to them the importance of acknowledging our history and the importance of setting up a respectful relationship with our First Nations communities in Queensland. And I think that there is actually an opportunity there for First Nations groups in Queensland to take advantage of the current situation where the government, I suspect, realises that they have made a misstep here. And so I do think there's actually an opportunity to turn a terrible situation into something that is a bit better. So I'll just move to the next slide and actually get into the year that has been. And again, can I just thank all of you for your interest in human rights and for this network, and thank you, Kikos, again for convening this event. And it is a very esteemed panel. Really looking forward to hearing from the other panelists as well, including Daney, about the national campaign. And Daney, I just want to acknowledge the work that you've done over many years now. And every year we get a little bit closer, I think, to a national act. But here in Queensland, so a major development was in May when the Supreme Court finally handed down one of the COVID-19 related decisions in Johnson versus Commissioner of Police. It was significant in that litigation and the other cases around COVID-19. One thing they did do is educate Queensland's barristers about the operations of the Human Rights Act. So there was one day where we actually didn't have any staff in the office, and we intervened in a few of these matters, and I actually had to go and take some material up to our counsel in the court, and I was struck by just how many lawyers there were at the bar table, and so a lot of QCs that otherwise wouldn't have had cause to actually look at the Human Rights Act did become educated in the Human Rights Act as a result of this litigation. So it's quite significant. The upshot of the decision itself was mixed in that there was a finding by the court that the Commissioner of Police acted unlawfully in not giving proper consideration to human rights in making the vaccine mandate. The downside of the decision was that it was found that that didn't invalidate the direction. So it was somewhat of a Pyrrhic victory for those litigants. In April, the Anti-Discrimination Act was updated and includes new attributes of sex characteristics to ensure coverage of intersex people in the Act. The vilification and serious hate crime laws were also updated to increase penalties for the criminal offence of serious vilification, which was also moved from the Anti-Discrimination Act into the Criminal Code to make it more accessible to police officers. Sex characteristics was added as a protected attribute for vilification, and a new offence of publicly displaying a prohibited symbol, including the Nazi cross, has been prescribed as a prohibited symbol in the regulations. Also in April, there was an important development in Queensland with the establishment of the Victims Commissioner, and I'm sure you'd all agree that Beck O'Connor's been doing a great job in that role since her appointment. In May, we had a significant development as well when sex work was finally decriminalised, and a legal framework for the sex work industry in Queensland was established. We've seen some major improvements in the legal protections for sex workers, and again, this is a long overdue reform, and it's a real credit to those advocates who were successful in getting that up. In June, we had provisions of the Births, Deaths and Marriages and Registration Act commenced, and that increases recognition of trans and gender diverse people and diverse families on birth certificates, removes barriers to changing the record of sex, and ensures that people are recognised across the state as their registered sex. And then in September, the second last sitting day of the term of Parliament, and I can tell you there were quite a few of us without any fingernails left that week, because it really came down to the wire. But the Respect at Work bill was passed, and it included a number of amendments that were made from the floor that implemented quite a few of the recommendations that we made in our Building Belonging report from 2022 that reviewed the Anti-Discrimination Act. And of course, next week we've got Human Rights Week from the 1st to the 10th of December, and we're in the 5th year of the operation of the Act. No doubt Elena and Janet will be talking about the review of the Act, so I'll let them talk about that. But in my view, we've made some steady progress within the government, but the reality is we're at the start of the journey, and we know from our discussions with our Victorian and ACT counterparts that it's a long haul in developing a strong human rights culture in the public sector, and it requires constant waves of education and vigilance. So as we move into next year, we'll be looking to develop that second wave of education, both within the public sector and the broader community. And some good news on that front is, as a result of the amendments that we had in September, the Commission has received additional resources, and we're currently in the process of going through a recruitment program to build the Commission's capacity from around about 50 staff to about 80. So that is exciting and a logistical challenge for me at the moment. So from 1 July 2025, and this was one of the most exciting outcomes of the new amendments, there will be a legal obligation on duty holders, so businesses, organisations and government agencies, to eliminate discrimination, and this is called a positive duty, and will apply to all conduct prohibited by the Act. So unlike the Commonwealth provisions, which are limited to sexual harassment, this will be all forms of discrimination and prohibited conduct under the Act. It means that duty holders that are currently vicariously liable will now have a positive duty to take proactive steps. So this is all about responding to what we heard in our consultations in the Building Belonging review. Came through very clearly from the community that they wanted to shift the burden away from individual complainants and onto businesses and organisations. But we also heard that the community was calling for a much stronger proactive role on the part of the Commission, rather than just simply being a body that receives and conciliates complaints. This new regime will provide for the Commission having a more proactive role in working with duty holders to prevent discrimination from happening in the first place. And so it's important for you guys to know, as duty holders, that you will be required to take reasonable and proportionate steps. But likewise, it's also important to know that the expectations on duty holders will be tailored to the size and the type of work that they are doing, and the amount of risk that is involved to particular people. So exposure to sexual harassment, for example, in particular industries will be a significant factor in the Commission determining which sectors we're going to work more closely with in the initial stages of implementing the positive duty. So also from 1 July 25, more Queenslanders will be protected from discrimination because they've extended the attributes to include people who are subject to domestic and family violence, homelessness, irrelevant criminal record or medical record or expunged criminal conviction, and also physical features. So the physical features is important to note that that's features that a person has no control over. And importantly, and this was a very significant amendment, there's been a change to the definition of direct discrimination, so that some of you who may have practiced in this area may be aware that there was a need to argue and identify a hypothetical comparator to compare a person's treatment to, and that will no longer be necessary. So you can still use a comparator when it's helpful, but when it's unhelpful, which occurs quite often, particularly in relation to disability complaints, there will no longer be a need for a complainant to identify a comparator. So this makes the law easier to understand and apply. Also from 1 July, the time limit for complaints will be extended from 1 year to 2 years. So that's a really helpful development and lines us up with the Commonwealth as well, which is useful. And Queensland has also introduced reforms that came out of Kate Jenkins' Respect at Work report, including prohibitions on sex-based harassment and subjecting people to workplaces which are offensive, humiliating, or intimidating on the basis of sex. And arguably, these were already covered in Queensland, which does have, actually, Queensland has probably the best sexual harassment provision and has had for some time. But these new provisions will really make it very clear what would otherwise be direct or indirect discrimination. And go to the next slide. Also, there have been important changes to vilification laws. So additional attributes that are now protected from vilification in Queensland include age. And again, a shout out to those people who advocated strongly with the Attorney General around that. Sex and disability are now all protected from vilification. And there's also a new harm-based vilification provision, civil provision, which mirrors Section 18C from the Racial Discrimination Act. That's been introduced, and that is likewise an important development in Queensland. And the definition of public act has been refined to make it clear that some workplaces, such as schools, that there have been cases from various jurisdictions where they've decided that those kind of workplaces weren't public spaces. Well, Queensland's laws have been amended to address that issue to ensure that if they are of a public nature, that they will be included within the definition of public act. So in terms of preparing for 1 July, as I mentioned, we're in the process of getting ourselves organised internally at the Commission with a recruitment program and a restructure. Come the new year, we'll be working closely with industry groups and peak bodies as we develop some guidance materials to help duty holders understand their obligations. So under the Act, we will be publishing guidelines, and we'll be consulting with industry groups, including QCOS and others, in the process of developing those guidelines. So I think that is all that I have, and I'm happy to take any questions.
Thanks so much, Scott. Yeah, that was fantastic. What we might do, if it's okay, is we might have a section in the agenda where we will ask questions with all of the speakers present, and we'll keep moving along. But yeah, that was really great, and lots of very busy year. So some really good success stories there as well. So next I'd like to introduce Elena Marchetti, who's the co-director of Disrupting Violence Beacon, professor with the Griffith Law School, and Jeanette Ransley, who's the professor of Griffith Criminology Institute and School of Criminology and Criminal Justice. So I'm sure that many of you will know about the recent Queensland Human Rights Review that took place this year. So our next presenters are going to talk a little bit about that and how that consultation process looked across when they were travelling across the state. So Elena is the co-director of the Disrupting Violence Beacon. She's also a member of the Australian Research Council, College of Experts, and Deputy Chair of the Queensland Sentencing Advisory Council. So Elena completed her PhD in 2005 on how the Royal Commission into Aboriginal Deaths in Custody considered the experiences of Aboriginal and Torres Strait Islander women whose deaths in custody were investigated by the Royal Commission. So since completing her PhD, she's been the recipient of 2 prestigious Australian Research Council fellowships, an Australian Research Fellowship that considered the impact of using Indigenous sentencing courts for partner violence offending, and a future fellowship that aims to explore different ways of evaluating Indigenous-focused criminal justice programs. And Janet, who is the professor in the Griffith Criminology Institute School of Criminology and Criminal Justice. So prior to joining Griffith as a lecturer in 1999, she held her senior policy positions with the Queensland Legislative Assembly and for the Criminal Justice Commission. That's now the Crime and Corruption Commission, and has worked as a solicitor. So I'd really like to welcome them. We're really looking forward to hearing about the review and how it went for you from your perspective. Thank you so much.
Thanks very much, Sam. And I am going to kick off, and I would like to start by also acknowledging that I come to you from the traditional lands of the Yagara people and extending my respect to elders and all First Nations people throughout the state. I would like to say that the actual reviewer, the independent reviewer of the Human Rights Act, Sue Harris-Rimmer, sent her apologies. She would love to be here, but she's enjoying some well-earned rest and recreation at the moment. So we're going to do our best to make up for her. It requires 2 of us to do that. So, I'm going to start with a little bit of background, and then Elena is going to hone in on some of the issues that were raised in our issues papers and some of our consultations and discussions throughout the state. So as Scott's already mentioned, the Act itself required an independent review to be conducted after 5 years of operation, both into the provisions of the Act and importantly into its implementation, which is often the most difficult part with legislation. Sue Harris-Rimmer was appointed at the end of February. She was given broad terms of references, but a requirement to report by September, which is a pretty short time span for this kind of review. So she brought on some other people to assist, including us, and our names are up on the slide, so I won't repeat them. And we did, in fact, deliver our report and recommendations to the Attorney General, the then Attorney General, on the 30th of September. By that time, of course, we were in caretaker mode, or election mode, so the report hasn't been tabled, and that means that, unfortunately, this is a bit of a Clayton's talk because we can't actually talk about the contents or the recommendations of the report. So you'll have to wait until that report's been tabled, which hopefully won't take too much longer, and then I'm sure Sue would be very keen to come back and talk through the outcomes of the review. But we do think that there's some interesting things to learn from the process that we've gone through and from the issues that have been raised. So that's what we're focused on. So next slide, please. So consultation was incredibly important, and given the short time frame, we really needed to approach this from a sort of multi-pronged approach. So I've got on the left-hand side there Sue's overall commitment, which was to ensure that we had as broad, diverse consultation as possible, and that we particularly prioritised the voices of the most rights affected in the Queensland community, who are often the most difficult to access people as well. So I think that was an overwhelming consideration of the consultation process. So we did the usual things in terms of looking at what the literature and what prior reports have said. We were able to draw on an extensive survey conducted by Sue and colleagues only a couple of years ago, which investigated how the Queensland public actually feel about human rights and what human rights they prioritise, and obviously that was very helpful. We released 3 discussion papers targeted at various things, and Elena is going to talk about them in more detail in a minute. We conducted an online survey, which was particularly targeted at people who had experience in using the Act or not using the Act, and what they felt that they learned from that experience and how beneficial it was and what some of the problems and barriers were. And we were really pleased that a significant proportion of the respondents came from outside South East Queensland, knowing that Queensland is geographically diverse and that not everything goes on in the Brisbane area. We received 92 written submissions, which we were pretty pleased with given the time frame. And in addition to that, Sue in particular, but all of us really made an effort to get out and talk to people. So to conduct extensive discussions, consultations, including with a number of forums open to the public. So in total, we met with about 22 organisations, so government agencies, NGOs, human rights bodies, members of the judiciary, bar associations, the law association, the usual suspects, really. But we also held public community consultations in 4 predominantly First Nations communities, probably not Townsville's, not predominantly First Nation, but has a very significant First Nations community and some very significant problems experienced by the First Nations community in Townsville. So we went to Thursday Island, Palm Island and Cherbourg, as well as Townsville. And that was really important in our and helping us to understand particular perspectives to bring to the report and to its recommendations in relation to First Nations communities. And we held 2 forums in Brisbane, which were open to the public, which were particularly focused on the issue of new rights. So the terms of reference of the review, and indeed this was also set out in the legislation, required us to consider whether there were any additional rights which should be added to the protections given under the Human Rights Act. So we focused our forums particularly on those issues, and those were quite lively forums. Okay, the double act starts now. I'm going to hand over to Elena to talk about some of the issues.
Thanks, Janet. And if we can move to the next slide, and I'll quickly also acknowledge the traditional custodians of the land upon which I'm situated, the Jagera and Turrbal peoples, and echo Scott's words in relation to the, need for a truth-telling inquiry and hoping that it gets reinstated. And I know it's been recorded, but I'm happy to voice that support. And it is a shame that we can't really talk about the content of what was discussed in these, community consultations, where we used the discussion questions, and there were a couple of papers, and we've provided the links there to those papers. But just really quickly, they were really, really interesting discussions, and surprisingly very well attended. So no, I shouldn't say surprisingly, but I guess for me, and we're always, happily surprised when people engage with these sorts of topics. Mainly we were asking people both from the community, but also, the general public, but also the public sector and public authorities, what their experiences were in relation to human rights, and asking about things like whether there should be any changes to the laws, whether there's, a correct balance between different rights. One of the differences between the two, the general public and the public sector, was really trying to gauge whether the Act had made a difference to the culture of the public service, and that was quite interesting. But one of the other areas of focus was in relation to remedies and what people thought about remedies, because I'm sure Scott can answer more questions, more in depth, can provide a more in-depth answer to this question. But the remedies at the moment are quite limited, and they're often tied. They're very much limited in the sense that people can only get, for example, a conciliation where you might ask for an apology or some sort of, rectification or amendment to practices. But if the conciliation doesn't work, there's not much more that can be done. So you can piggyback an action to another action in terms of taking it to, a tribunal or a court. But even there, you can't get any compensation for the human rights breach. So we were asking, I guess, both the public sector and the general public whether those types of remedies are sufficient. I won't sort of preempt the answer to that, but you can imagine what the response was, and if not, you know, how we could change that. With the new rights discussion paper, so in there were a number of rights that really we listed initially, and they varied in terms of, you know, looking at housing, the right to pretty much be, you know, to, I can't remember how it was worded, but disappear, you know, not be present. I guess challenging that idea that we have to be connected to everything, and there's certain people who would like that sort of right. Of course, we looked at more, I guess, strengthening the rights of Aboriginal and Torres Strait Islander people, in particular whether there should be a separate recognition for self-determination, not just in the preamble of the Act, but also as a separate right. Although there are separate rights in relation to Aboriginal and Torres Strait Islander people in relation to cultural rights, we explored whether that should be, you know, expanded and made stronger. One of the, and Scott mentioned that there's a new Victims Commissioner in Queensland. So one of the areas we also explored is whether there should be some explicit reference to having rights in relation to victims, which some will argue that, you know, they already exist within what's already contained in the Act, but there's also been quite a lot of discussion about the fact that often that is very much the, you know, the focus is very much on a person being charged or a person defending an action through the criminal justice system. So it was really interesting to see what people came up with. There were discussions, and I won't go into the details for the reasons Janet mentioned, but there were discussions in relation to rights we hadn't even considered. So when the report comes out, yeah, I'm sure you'll all want to read it. But like Scott, Janet and I are both happy to take questions, so we'll leave it there.
Thank you so much, Janet and Elena. That was fantastic. And yeah, I know just from personally participating in that consultation process, it was absolutely fantastic. So just want to thank you and your team and Sue for doing such a great job with that. And I'm sure that this group will absolutely love to have you back again, and Sue to talk to that report once it's tabled. So we really look forward to keeping an eye on that and seeing what happens with that. So thank you. So our next speaker, very excited to introduce Daney Faddoul, who's the campaign manager of the Australian Human Rights Act with the Human Rights Law Centre. So Daney is a vital voice in leading the campaign for the Australian Human Rights Act, and he's going to give us a bit of an overview of what's happened this year and also where it's going into next year as well. So Daney joined the Human Rights Law Centre in March 2020, and he focuses on the campaign to create the Australian Human Rights Act. He has a wealth of campaigning experience from his time with the union movement and also at Get Up, where he was the senior campaigner and then their political director. So at Get Up, Daney developed and led campaigns on economic justice and oversaw all of their political engagement activities, and he also assisted with a wide range of high-profile campaigning and policy work. So welcome, Daney. I'm just going to stop sharing my screen because Daney's not going to use the PowerPoints today, so it'll be nice to see you. Hopefully we can see you now, Daney.
Fantastic. Thanks so much for that. Hi, everyone. Such a pleasure to be here with you today. I'm coming to you from the land of the Gadigal people of the Eora Nation, and pay respects to elders past, present and emerging, and also acknowledge that sovereignty was never ceded. It's great to be able to talk about the Federal Campaign for a Human Rights Act. Before I dive further into it, I might want to give a quick reminder about what we're talking about, because Amnesty International does polling every year. And what it found is that when asked, 75% of Australians support a Human Rights Act. However, 51% of Australians think we already have a National Human Rights Act. So there's a lot of folks out there who don't know what human rights standards there are, or even worse, think they know, but what their answer is actually incorrect. So I might do a quick rundown of like what is a Federal Human Rights Act, what it contains, before I dive into the events of the last year, because the events of the last year have been fairly helpful as well as hopeful. Because a Human Rights Act would cover federal public authorities, so it would work alongside the Queensland Human Rights Act, which covers state and local government public authorities. It would cover economic, social, cultural, civil, political, and the right to a healthy environment. So this would be things like the right to education, the right to health, the right to housing, freedom of association, the right to dignified treatment, the right to life, equality before the law. All of those rights will be contained in a Federal Human Rights Act. And the thing to remember is that a Federal Human Rights Act doesn't just cover federal laws, it also covers federal policies and services. So if you're thinking about service delivery at the federal level, things like the National Disability Insurance Scheme, the aged care system, Centrelink or Services Australia, and the social income support system, all of those and plenty more services will be covered by a Federal Human Rights Act and have to apply and consider federal human rights standards. And the good news is that means everyone benefits, because a Federal Human Rights Act means you put those values of equality, freedom, compassion, and justice at the heart of laws. Because right now, there isn't an obligation for federal government authorities or service providers to have to consider human rights. They may. There may be specific laws which may dive a bit into it, but they don't have to. And the problem is that we've had no shorter than 3 major royal commissions over the last 5 years, robo-debt, disability, and aged care, which have highlighted the dreadful consequences of not having enforceable human rights standards in law. And in the case of the aged care and disability royal commissions, their key recommendations included putting enforceable human rights standards in to ensure we don't have those same systemic problems reoccur, and therefore requiring yet another royal commission to dive in and see what went wrong and what could be done about it. So the good news is that since March 2023, the Federal Parliamentary Joint Committee on Human Rights has been inquiring into Australia's human rights framework. And as part of that, considering whether there should be a Federal Human Rights Act, and as part of looking into the experience of Victoria, ACT, and Queensland that have had human rights acts, or in the case of Victoria, they call it a charter, as part of considering whether the Federal Human Rights Framework should have a Federal Human Rights Act. And the great news is on the 30th of May, it reported back and reported yes to a Federal Human Rights Act. But what makes me have a little nerd dance is that it also had an illustrative Human Rights Act at the back of the report. So I might ask the link to the Parliamentary Joint Committee on Human Rights report page get posted in the chat. So have a look at the report and the illustrative Human Rights Act, because what it does is list all of those human rights standards I just outlined. It's all listed there. It provides for direct cause of action. So unlike Queensland or Victoria, where you have to attach another right, like discrimination, before you can then talk about the rights under the Human Rights Act, you can actually directly take forward a complaint about a breach of your federal human rights if by a federal public authority. It has things like a right to healthy environments. The ACT just placed a right to healthy environment in their Human Rights Act back in August. It has that in this Federal Human Rights Act that's been proposed by the Parliamentary Joint Committee on Human Rights. And it even has an inquiry into whether to place Aboriginal and Torres Strait Islander self-determination as a clause in the Human Rights Act, but it's asked the Australian Government Solicitor to look into how that can be best expressed and if that is justiciable. In other words, can you enforce that right? Because if that right can't be enforced, then there's no point putting a clause in a Human Rights Act outlining a right. So that is an incredible step forward we've taken. That's the closest we have taken a Human Rights Act nationally since the 1980s. Further than the Rudd review, because that was an independent inquiry. This is parliamentarians saying we should have a Human Rights Act, and the parliamentary inquiry was headed by Josh Burns from the Labor Party. It was government MPs giving a thumbs up to a Human Rights Act in this report. So that's fantastic news. And little wonder that they will be recommending yes to a Human Rights Act. As Scott can attest in terms of the Queensland Human Rights Commission and his colleagues in Victoria and ACT, there is a wealth of examples showing the benefits of having enforceable human rights standards in Queensland, the ACT and Victoria. And we've taken the opportunity of compiling 101 of those examples on a website. So you can have a look at them. You can search those examples by the right being exercised, by the beneficiary, by the jurisdiction. And we've also got 6 videos where people talk firsthand about how they've either benefited from having human rights at the heart of the laws and been able to exercise them when their rights weren't being respected, or advocates and how they've been able to use the Victorian Charter, the Queensland Human Rights Act, or the ACT Human Rights Act to resolve a problem. And one of the examples includes QCOS's own Amy McVeigh and Tenant Queensland as well, talking about how they use the Queensland Human Rights Act to ensure they're able to support people when it comes to fearing and facing eviction, including a domestic violence survivor who was able to avoid being evicted because of the actions of her abusive ex-partner in breaching the terms of the lease of her social housing. It was the Queensland Human Rights Act that was able to make sure that she wasn't evicted and was able to have her rights respected. So it's little wonder the Parliamentary Joint Committee on Human Rights said yes to having a Human Rights Act. There's one small problem, of course. Parliamentary inquiries don't implement themselves. There has to be a decision by the federal government to say yes to implementing a Human Rights Act. And so we're still waiting for the federal government to provide a response. I think a good clue that the federal government is taking this seriously is that the Parliamentary Joint Committee on Human Rights didn't decide by themselves to inquire into Australia's human rights framework and whether to have a Human Rights Act. It is unusual. It is one of the few federal parliamentary inquiries where it can't do its own inquiries. They actually require a reference from the Federal Attorney General to be able to inquire into something, and the Federal Attorney General asked Mark Dreyfus asked them to look into a Human Rights Act as part of considering Australia's human rights framework. So it's clear that the federal government's got an open mind on this issue, but they haven't made a decision yet. They have not responded to the inquiry report just yet. But the good news is momentum is continuing to build. So to give you a few examples, back in July, the group of disability representative organisations led by Women with Disabilities Australia and National Disability Advocacy Network Australia pulled together a joint statement calling on the federal government to respond to the Disability Royal Commission recommendations by agreeing to enact a Federal Human Rights Act. We had the COVID inquiry that was conducted by the federal government, by the Department of Prime Minister and Cabinet. It held a whole series of roundtables, including a human rights roundtable. It took submissions from organisations from the public. And in the report that they released a couple of months ago, it indicated that in fact, in consideration of human rights, was an essential thing that needed to be considered and put in place for dealing with pandemic and crises like in the future that would be similar to the COVID-19 crisis that we experienced. And as part of looking into it, that COVID-19 inquiry considered the experience in Queensland, Victoria and ACT of how their human rights acts and part of improved decision-making at that level and gave people the ability to take action when their rights aren't being respected. And another development was just yesterday. Last night, the Australian Human Rights Commission released their National Anti-Racism Framework. They knew I was speaking today. And so this framework was released, and recommendation number 8 is for an Australian Human Rights Act. And one of the reasons why a Human Rights Act is a critical element of that is because when it comes to human rights benefiting everyone, it benefits everyone, but it benefits marginalised communities more because they have a greater need to rely on human rights standards. They don't have their own resources or their own sway to be able to ensure their rights are upheld. They need to rely on enforceable human rights standards to assist make sure that they're making sure that their rights are upheld. And so that's why the Anti-Racism Framework released last night by the Human Rights Commission includes a Human Rights Act as one of its key recommendations that it puts forward. So that shows that we're making continuing progress and there is momentum. And that's the great news. However, we're also coming up to a federal election next year. And so that federal election will be a critical moment to determine whether we will see a Human Rights Act become a reality or if it'll be deferred yet again. So that, I think, is going to be a critical moment moving forward. But the progress we have achieved this year means we are so close, the closest we've been for 4 decades to achieving a Human Rights Act. And we have a federal government that is open to it, and there is a lot of goodwill across the federal parliament for a Human Rights Act. And a Human Rights Act has been regularly considered and raised in a number of discussions and bills and inquiries that have been going forward after the time for the human rights inquiry as well. So the great news is that we're making progress. There is momentum in this issue, but we're not there just yet. And that's one of the other things to particularly note, which is that it is only by people talking about a Human Rights Act that we make it a reality. The lessons from the amnesty polling that I mentioned earlier is a lot of people think we already have a Human Rights Act. You're not going to call for a Human Rights Act if you think one already exists. So making sure we spread the word about a Human Rights Act is really important. And that's why on our Human Rights Act campaign website, we've got a whole bunch of resources you can turn to. From a messaging guide that outlines the most effective way of talking about a Human Rights Act to people in the community to bring them on side, to fact sheets that help outline what a Human Rights Act can do, what benefits it can provide, and the problems that it helps redress in a whole bunch of different areas, whether it's by the right being exercised or by the part of the community that we're talking about. We're continuing to build and grow that list of resources and fact sheets. So that's a great place to have a look at. We also have reports. 2 reports are there on the right to health and the right to education that we've released, and we're hoping to release one on the right to housing next year, so stay tuned for that. But all of those resources are there to help people talk about the Human Rights Act, why we need one, and what we can do together to help make it a reality. But the final thing I'd probably note before I hand it over to questions is, of course, it's important to be part of the campaign. So on the Human Rights Act website, humanrightsact.org.au, you can sign up to the campaign, and that's on an individual basis. And if it's an organisation that you want to sign up to the campaign, welcome aboard, because we have 113 organisations across this wide continent that are part of the Human Rights Act campaign as partner organisations, including QCOS. Thank you, QCOS, for your strong support. So by coming aboard and getting involved in the campaign, we can make sure that we are greater than the sum of our parts by collaborating, working together to drive forward call for a Human Rights Act to make a reality. Because at the end of the day, everyone benefits from having human rights at the heart of our laws, and together we can make that a reality. Thank you.
Thanks so much, Danny. That was fantastic and really great to hear what's happening more broadly in human rights and how the Act sits alongside the Queensland Human Rights Act as well. So yeah, congratulations on the progress that was made in that space this year. So really, yeah, again, encourage people to join that campaign. So we're going to hand over to questions now. So I'm just going to introduce you to Ryan O'Leary, who's with QCOS, who's going to be taking questions. And yeah, please post them in the chat or come off mute, and you're welcome to ask questions to any of the speakers.
Thank you, Samantha, doing a fantastic job. I'm here filling the enormous shoes of Stacey DeCarmo, who's having some internet issues. We'll probably only have about 5 or 6 minutes for questions, so there's always more that we can talk about, but we want to make sure we keep the 5 minutes at the end for some important announcements of other opportunities to engage. Scott, I might just start with you quickly with a jumble of questions, particularly just around if there's any key advice you have for community organisations in their need to prepare for the changes as service providers and employers, and if there's any key kind of timeframes or deadlines and the best way to access information. I'm aware I've jumbled a few there for you, but over to you.
Thanks, Ryan. Yeah, so the critical date is the 1st of July, which is when the positive duty starts. In terms of information, probably the best place is still our website. So if you just go to the QHRC website, we've got good information there. My advice in terms of you guys being duty holders is really to take stock of where your policies are at and where your training is at in terms of prevention of sexual harassment and discrimination. So as a board, the board really needs to be addressing where the potential risks are for the organisation. So and you need to be looking at proactive measures to address those risks. So, but as I mentioned earlier, our approach is going to be collaborative. We're not going to be rocking up on your doorstep on the 1st of July carrying a big stick and dragging you off to court. That won't be happening, but and we'll be starting in terms of the regulatory powers that we have. Quite often you'll see them displayed as a pyramid of powers. So at the apex of those powers are our enforcement of enforceable undertakings. So we can give compliance notices to those duty holders who haven't complied with undertakings that they've provided to the Commission. But to get to that apex, there's another couple of layers of regulatory powers which start with education. So our focus as regulators in implementing positive duty is really going to be initially with education, and then we'll move from there. So wouldn't want any of you to be alarmed, but you should be modelling best practice, particularly as members of the Human Rights Network. So the starting point is understanding as an organisation where your risks are. Hope that helps, right?
Yeah, thank you very much, Scott. And I can see there's more questions coming in the chat. Please keep posting in there, and we'll do our best within the time we have to respond and follow up afterwards for anything else. Janet, I wanted to ask you a question next, if you wouldn't mind, around how community organisations can effectively advocate for the implementation of the review's recommendations, the Human Rights Act review, kind of the role that our members can have in pushing this further.
Thanks for that, Ryan. And I think it's a good question. And I also think that Daney gave us some valuable advice during his presentation around the need to be involved in processes. I mean, once our report is tabled, the need to take it on board, to think about it, to if there is any further processes such as parliamentary committee hearings or reviews of proposed amending legislation, that people engage with that. But I think the more important thing, particularly for some rights issues in Queensland, is we don't have a great public discourse around particular issues at times. I think it's no surprises to anybody that I would say youth justice is one of those issues at the moment, has been for quite some time. We really need to do a better job, and as speaking as an academic working in the area as well, of explaining to people exactly what those issues are and exactly what's involved when people want to infringe human rights in relation to those kinds of issues. So I think that's incumbent on everybody with an interest in the area, is to reach out through those less formal mechanisms. We do a good job. The community sector in Queensland does a great job of responding to formal inquiries. It always amazes me how many submissions there are, but we need to do a better job with the community, the parts of the media, and the political agenda. I don't know how though, so sorry about that.
Thank you very much, Janet. Now, I need to extend a very humble apology to Daney and Elena. I don't think I have enough time here to go through some of the questions that we had planned there. And there was a very natural opportunity for a segue there with Janet highlighting the youth justice area. And that's one of the main things I want to hand to my wonderful colleague, Lauren, to discuss in terms of the what we're expecting but possibly today or tomorrow from Parliament, and some of the opportunities to engage with the submission process. So apologies, Daney and Elena, and please everyone keep posting in the chat as needed. Lauren, over to you.
Thank you, everyone. This really is well timed. We've spoken a lot about some really major reforms that have happened this year and really great steps forward. A lot of those moments have been supported by really strong submissions and engagement with advocacy processes. Sam, if it's possible to share the PowerPoint again, and we'll also be sharing a few links to some of the things that are open at the moment for submission now. This week, we're going to be expecting some laws introduced regarding youth justice and we know that will include the implementation of the adult crime, adult time policy, but it'll potentially include some other things as well. So QCOS has been coordinating the Queensland Raise the Age campaign, and we've been working with the community sector to develop those alternative asks and to sort of highlight what we'd like to see instead of tough on crime approaches, which we know don't work. We have published some initial guidance to help explain what we're expecting to see in the bill, some of our initial positions based on announcements so far, and also how you can connect with us and with other community service organisations who are going to be active in this process. As you might be aware, we have a sitting week this week, then a break, and then another sitting week, and these laws will be passed within that time. So it'll be quite a tight turnaround time for all of this. We do have a meeting scheduled on Monday for anyone who would like to join us for that meeting. And Sam, if you could just go back to the previous slide, just reach out to us on research@qcos.org.au, and you'll be very welcome to join us for that discussion session. We'll also be updating our online guidance with any more information that becomes available. We may also see some other bills introduced in Queensland Parliament either this week or mid-December. So something that we'll be keeping an eye on would be whether there's anything in relation to the path to treaty, but there could be other things coming up as well. So that link to the What's New section of Queensland Parliament is a really good one to keep an eye on because that will go over any new bills that are introduced. And Ryan, if you could post the link to our online guidance in the chat, that would be really helpful. I'll go over to the next slide briefly because there are a couple of other things coming up. You may be aware the Queensland Police Service have a watch house review at the moment. They have called for submissions, so we'll likely discuss that at our session on Monday. There's a lot of issues that are connected with that, and in particular QCOS has been calling alongside a number of other organisations to end the practice of holding children in adult watch houses. So we'll be keen to engage with that submission process as well. You may have seen that the Truth Telling and Healing Inquiry has made a final call for online submissions. Any submissions and materials that are provided to that inquiry will form part of the inquiry's records and will be collected and preserved by the Queensland State Archives. So that's a really important opportunity to engage with that process. And just moving over to our last slide, I'm sorry I'm taking up a bit of time, but QCOS engages with the Queensland state budget process every year. We're currently calling for feedback on our papers. We cover a number of themes across our major areas of advocacy. We're seeking feedback by the 13th of December, and once we publish them, they'll be open for comment again. So if you have any interest in connecting with us about any of these things, please do reach out and we'd love to hear from you. I'll hand it back over to Ryan. Thank you so much.
Thank you, Lauren. It's been an enormous year. It's lovely to have this session to reflect on things, but the year is not over yet. So there's obviously a lot of work still to do. And we do really encourage you to participate in the meeting on Monday as well as other processes. Folks, we're right on 11. Sam, are you able to put the poll up for people to provide their feedback on the meeting? Because we're always interested to hear your thoughts and reflections. While that's happening, I do just want to sincerely thank our guest speakers, Commissioner McDougall, Elena, Janet and Daney, for generously sharing your time and insights today. Apologies, we didn't have more time to unpack things. I've found over the years of doing these wonderful webinars that you could spend a long time really unpacking and tapping into the expertise and wealth of knowledge that our guest speakers like yourselves have. For folks in the audience, thank you very much for joining us. This is our last of these meetings for 2024. What a year it's been. And we encourage you to keep an eye out. We've got our final human rights newsletter of the year, which will be circulated on the 10th of December, which for those playing at home is obviously a very significant day, being World Human Rights Day. So please keep an eye out for that. We'd really love you to engage with the Mentimeter poll here, just to help us continue to reflect on how we can improve this whole process. This is obviously a very important part of QCOS's work that no doubt will continue into 2025 and beyond. Please join me, everyone, in thanking virtually or physically thanking our wonderful guest speakers. Your time and commitment and expertise is really appreciated. Thank you, everyone. We'll keep this open for a little bit for the Mentimeter access. Otherwise, I'm sure you have very busy days to run to. So we'll keep this open, but you're welcome to head off into your day as needed. Thank you very much.